next to me. The time now is 9 o'clock. Our meeting is scheduled to start at 9. We have received an apology from the public protector and her legal team that they would have landed this morning at 8, so they would be on their way physically here. So I want us to give them a few minutes and then we'll start when they are here. If that's in order with the members, but I wanted 9 o'clock to indicate that that would have been the start of the meeting, but because of the request, I will delay the actual formal start until when they arrive. Can we do that? Thank you very much. You can go and get your teas and other things as we wait. Thank you. Thank you.
Cheers. Cheers, Chair.
at M46 here and on a virtual platform. Welcome to the Public Protector here at M46 and her legal team led by Advocate Mpofu, also here. Welcome to the evidence leaders, Advocates Bawa and Mayosi. Welcome to the media present with us, our support staff, and the members of the public. Hopefully you can hear us in your YouTube and 408 platforms. Firstly, to just start up front and apologize for a late start. Hopefully now that things are underway, we would be able to proceed as expected. And maybe that's to do with the fact that we have not been in this for a week now, and I can see the break of that momentum. Having said that, I just maybe before I make my own remarks, just to check if Ms. Thejane, are you there on the platform?
Good morning, Chair and members. I am here. Thank you, Chair.
Okay, thank you very much. I'm asking you for your attention so that I appreciate that you were with us 7 days ago. Last Tuesday, you are here with us today. Today, we have quite a number of issues on the agenda. The main issue would be the recusal application that I'll refer to later. And for that, I would want to excuse you for the day. We will indicate to you when you are needed. Thank you for coming. You are excused.
Thank you very much, Chairperson. I note that, and goodbye.
Thank you. Appreciate it. And therefore, I'm going to, before we proceed with the business of the day, going to make a couple of remarks from the chair, and going to put certain issues on record, especially with reference to what would have transpired after we adjourned the hearing on Tuesday, 13 September. And I do this to update members and the public alike in relation thereto. So I'll spend a few minutes to do that. And thereafter, we'll ask the secretary to place one or two issues that will come from my remarks. And after that, we're going to invite Advocate Mpofu, leading the Public Protector team. Members would have received an application for recusal, and we want to invite him. Members having read what you have received, we want him to place and take us through his own salient point, and we'll give him a very reasonable time to do that, between an hour and a half to 2 hours. Hopefully that will be enough to allow him to place on record the recusal application. But let me quickly make my own remarks that by way of background, what was scheduled for last Tuesday was the cross-examination of Ms. Nelisiwe Thejane that I've just excused now, which have been followed by members' questions and the evidence of Mr. van der Merwe the following day. Prior thereto, on Monday, 12 September, a letter was received at approximately 12 o'clock by the committee secretary from the PP's legal team requesting a postponement on the day. At all, there is for me 1 o'clock on the same day. Obviously, I could not really meet as I consider the request to make a fair determination. After considering this request, I responded, included in that response a proposal on the way forward. This proposal included the PP's team's cross-examination of Merwe during week, in this now, but allow the cross-examination of Mr. to be complete, as I was told. Advocate indicated to the leaders that he would not likely be more than an hour in such cross-examination. A copy of the correspondence will be made available by the Secretariat. Shortly after the proceedings commenced on Tuesday, and whilst awaiting the arrival of Ms. Thejane, who was delayed due to technical difficulties that we all witnessed, Advocate Mpofu SC indicated that he was seeking a postponement of the sittings of the committee for 13th and 14th September, as foreshadowed in the letter of the previous day. The application for postponement was sought in the context of a court application that had been brought by the PP in the Western Cape High Court on an urgent basis. This, yeah, I saw that. I don't know, maybe somebody does not want to see the chair. I don't want to suspect who that is, but it must be fixed, but it won't stop. I'm sure you can hear. This following a ruling of the Western Cape High Court, which had found the president's conduct in suspending the public protector to be unlawful, and at the same time had upholding the legality of these proceedings of this committee and declining to interdict or stop the work of this committee. Hence, in the absence of any interdict, the committee is to proceed with its work. In its submissions in support of the postponement of the hearings, extensive references were made to the papers received relating to the application for leave to appeal to the Constitutional Court filed by the Democratic Alliance and the Public Protector. On inquiry, evidence at that stage, no papers had as yet been filed by the respondents in the Western Cape High Court. However, in addressing the issue of a postponement, Advocate Mpofu indicated that he had been involved in the drafting of papers until the early hours of that morning to meet a filing deadline of 9 a.m. and as such was not able to prepare for the cross-examination of Ms. Thejane. Advocate Mpofu also raised with the committee that the public protector had taken ill, but that he did not have the details of such illness or any further information at that stage. Neither was he submitting an apology for the PP's non-attendance at the hearing. It was made clear that he had no knowledge as to what ailed the PP. Prior to this announcement, neither I nor the Secretariat had received notice that the PP would not be in attendance as expected, and the only available information provided was that the PP had gone to the doctor. After hearing Advocate Mpofu's request and following questions from the evidence leaders and the views expressed by some members, I ruled that the cross-examination of Ms. Thejane will stand over, given that Advocate Mpofu was not ready to proceed. However, mindful that the proceedings were already behind schedule, and in the light of the rules of this committee, which require that it must conduct its business within a reasonable time, I also ruled that members may proceed to question Ms. Thejane, as I was of the view that we had secured the witness already, and that time should not be wasted. In considering this, I had due regard to the fact that the PP and her legal team, in any event, had no entitlement to intervene in the questions from the members, and that if irrelevant questions were asked, they would simply be disregarded. I was also mindful of the fact that this is not a court of law and the PP is not being prosecuted. Underlying this process is one of the fairness and no prejudice would result to the PP from such questions, given that the witness will be available at a later stage to answer questions under cross-examination in the event any issues arises during the PP's absence and the questions posed to Ms. Thejane. The PP's legal team would have ample opportunity to be able to take instructions in relation to any aspect that will be raised in the PP's absence in respect thereof. Weighing this up, I determined that the PP would not be prejudiced in any way. I further instructed the Secretariat to ensure that all members' questions and Mr. Thejane's answers be sent to the PP's team, and he advised that he ensured that the recording was sent directly. It was after commencing with the members' questions that Advocate Mpofu sought to interject and display what was referred to as a certificate, which by that stage he had received. I did not allow this in the middle of members' questions. As you would remember, you will have noted that to date I've taken care to ensure that sessions are not disrupted and that witnesses are, where possible, not made to have to sit through what is essentially committee business. This disrupts the flow and is unfair to the witness and to the members. I indicated clearly that the PP's 6 certificates should be sent to the Secretary. I did not deem it appropriate for me to permit the sharing of a document that contains personal information of the PP regarding her health in her absence and without the express consent of the PP, which we did not have. I've been at pains to remind the Secretary to ensure that personal information is not displayed where there is no lawful basis for us to proceed to process such information. Though Mr. Ngoma sent the certificate to me via email at 11:44 during the proceedings of the committee, as the hearing was still in progress, I considered it only once the meeting was adjourned, and the meeting was adjourned at 12:44 in terms of my timed written notes. Having satisfied myself with the content and having noted that it provided that the PP would be off for the rest of the week, I liaised with the Secretariat, instructing that the committee hearings would not be convened on the dates reflected in the medical certificate, and for him to amend the schedule and accordingly postpone the hearings. The postponement application was duly considered, and relief was granted with reference to the arguments made. In addition, I had ruled that only the direct evidence of the next witness would be heard, alleviating the need for preparation for cross-examination on the part of the PP's legal team prior to the hearings of the proceedings in the Western Cape High Court that had been brought by the PP. It would therefore be incorrect to suggest or say that I refuse to grant a postponement despite the PP being ill. On the contrary, I immediately took a decision to postpone the hearings upon consideration of the certificate. Those are the few comments I wanted to make up front. I'm now just going to quickly, for 5 or so few minutes, ask Thembi Nkosi, the Secretary of the committee, in relation to the matters that I would have raised, to raise some of those, place those on the record. And from there, we'll proceed to the PP legal team. Thembi Nkosi.
Thank you, Chairperson. Good morning, honorable members. Good morning, PP, legal team, and all those that are on the platform. Thank you, Chairperson. Yes, members would remember that the committee has not had a housekeeping in a while, so I thought it's best that I put the correspondence that has been received, the exchange of correspondence between the committee and various stakeholders before this committee. So what I've done, Chair, I've just prepared this table that I'll be talking to, just to so that there's a flow so members can see how correspondence had been received or went out from the committee. Chair, on 29th July, which is the very first one, we received a letter from the Commissioner of SAS, Mr. Kisveter. The letter sought to clarify the contents of the letters that was raised during the cross-examination of Mr. Johan van Lochrenberg. Members might perhaps wonder why they don't have this correspondence that I'll be tabling to this committee. The reason is that some of this correspondence contains person's confidential information. So as soon as that has been dealt with, then we'll upload all these letters on the committee storage platform, which is in this instance Uvimba. But there are a few letters that have been shared with members, including last week, that do not contain any confidential information. Just to proceed, Chair, on 1st August, we received another letter from Ms. Mawotwe of the EFF. It was a submission on follow-up questions to Mr. van Lochrenberg. And those questions were submitted to Mr. van Lochrenberg for a response. And as such, we have received that response. On 5 August 2022, Mr. Shivambu wrote to the chairperson raising an issue of the conduct of evidence leaders. That matter is also being dealt with, and at an appropriate time, a response will be provided. Chair, on 8th August, we received a letter from Sianeho attorneys requesting the summoning of the president. We responded to the letter and provided a legal opinion on the matter. That matter was talked to here in the committee, Chair. So we provided a legal opinion, which we sent to Sianeho. On 10th of August, Chair, we received a letter from Sianeho. They were requesting the recall of Mr. Lochrenberg and Mr. Pillay. We have since returned to Workmen's attorneys that represents the two, and we are awaiting the response. I have as such given them a deadline of the 26th of September to provide a response in that regard. On 15 August, Chair, we received a letter from Workmen's attorneys. This letter was sorry, Chair, it also spoke on the recalling of Mr. van Lochrenberg, where he indicated non-availability to appear for further cross-examination from the committee. However, that was before this other letter, Chair, so he responded to us before we had sent the initial request. Hence, we've just requested them to respond to our letter and provided them, as I had already indicated, the deadline of Monday, the 26th. Chair, on 16th August, the chairperson, on behalf of the committee, provided a response to Sianeho on the summoning of president. The request, as was discussed in this committee, was declined, and as I had already indicated, there was a legal opinion in that regard. On 19th August, Sianeho attorneys responded to the letter of the chairperson of the 16th of August and requesting also, and because that letter that went out also went out with the program of the committee, sorry, Chair, with the schedule of the committee sitting. So there was an extension that was requested for provision of witness list to the 24th of August, and that request was granted by the chairperson. And on the 24th of August, Chair, Sianeho indeed sent the list of provisional witnesses that was shared with the members of this committee. On 25th of August, Chairperson, you also wrote again to Sianeho, providing an explanation on the summoning process, because this is not relating to the president. We had returned to Sianeho to request that if they would at any event request assistance from the committee in terms of summoning the witnesses, they should indicate so. And also submit a witness statement. We gave, they requested, then Sianeho then requested that an extension which we gave, which was supposed to have been the 8th of September 2022. On the 5th of September, Chair, Workmen's attorneys, as I said, they provided an affidavit where Mr. van Locherenberg was responding to the questions as raised by Ms. Mawotwe of the EFF. And then on the 6th, Chair, before that, Chair, we had sent via email a draft addendum 1 to the directives restricted to Sianejo. However, on the 6th of September, we then received a response from Sianejo rejecting the addendum. And as such, no amendments have been made to the directives as yet. On 12th of September, Chair, we received a letter from Sianejo requesting that we adjust the program and also stating reasons therefore. And on the same day, we responded and the adjustment were then made to the program. And on the 13th, Chair, we received a, Chair, I must say that this letter came on the 12th, but it was dated the 13th. Came from Mr. Olomisa, also requesting that we postpone that meeting that was scheduled for the 14th. And Chair, the meeting, as everyone would know, proceeded, which then indicate that there is the request from Mr. Olomisa was also declined. Chair, on 14th of September, we wrote to Sianejo and then granting the postponement which you spoke to earlier on when we were addressing this house, that after you had received the medical and considered all that was placed before the committee, then you gave Temenkosi permission to then postpone the meeting that was scheduled for the 19th. And on the 14th of September, which is the same day, Chairperson wrote to Sianejo just because of what had transpired in the meeting, Chair, the Secretariat were unclear on what some of the matters that were raised in the meeting were indicating. Therefore, we wrote to them seeking clarity on the attendance of hearings that would so that I could be in a position to draft a revised committee program. We all know that that program is a working document. So yes, Chair, and then on 15th September, we received a response from Sianejo attorneys confirming attendance and also indicating that they intend to file a recusal application. And on 16th of September, Chair, we received a letter, again, my sincere apologies. On that letter of the 15th of September from Sianejo, it was also requesting that we postpone Monday to Wednesday, of which, Chairperson, we noted the intent to file a recusal application, and we also granted the extension as was requested, which is why we are sitting today but did not sit on Monday. On 19th September, Chairperson, we received a letter from a notice of a recusal application indicating that an application will be launched for the recusal of the Chairperson and Mr. Mailam. And Chairperson, on 20th of September, then Sianejo submitted, which is yesterday, submitted the recusal application for the Chairperson and for Mr. Mailam. And that was also shared with members. Chairperson, there's also, apart from, as I earlier indicated, that communication is between the committee and various stakeholders, not necessarily only Sianejo. So I have been writing to a number of persons where I requested information from them, which would have arose during the sittings of the committee or when evidence was presented to the committee. And as such, those the letters have gone out with annexures of what was presented here during the hearings to Ms. Keller, Kim Keller, and Mr. Siepe. And there's also a letter that was sent to Ms. Paloi, as Sianejo had also requested that she appear again before the committee. We're expecting a response before Monday the 26th. And so, as I had earlier said, Chair, that we wrote again to workmen's attorneys, also requesting that Mr. Pillay and Locherenberg avail themselves. We're expecting a response on or before Monday the 26th. And Chair, we also sent a letter to Mr. Hlatjwayo of Wekunene, a letter that contained annexures where we request information that we feel that it would assist the committee in its work. Same letter went out to Mr. Paul Ngobeni, also requesting same. And Chairperson, the last one, Chair, was the letter that we sent out to Sianejo, just detailing the order of proceedings for today. Chairperson, I tabled this correspondence to the committee, and as I have indicated that once we have done with the process of blocking out persons' confidential and personal information, we will then put up these letters on the committee page on Ovimba. Chairperson, thank you very much.
Thank you very much, Ms. Temegosi Ngoma, for that. And I will proceed, colleagues, to the next point, as I indicated earlier. I'm going to invite Advocate Mbofu and allow him his allocated time to take us through the recusal application. And I'm going to encourage members that, having received this and read, that I would encourage that you allow for an uninterrupted presentation. There will be clarities at the end. Thank you very much. Advocate Mbofu, over to you.
Thank you, Honorable Chair. Good morning, honorable members and everybody, our colleagues and members of the public. Chair, before you start to run the clock, let me also do my own housekeeping. Chair, I want to make the following proposal. Because on some of the issues that you have placed on the record, I would have wanted to respond to them now, but if you allow me, the deal is this, that if you allow me a few more minutes if I need them, so that I incorporate that response in my recusal application, rather than yes, so that it then gets into its place, as it were, in what I had planned. Thank you, Chair. I'll remind you if I need those minutes at the end. The other thing, Chair, just by way of housekeeping, is pertaining to the presentation by Mr. Ngoma. I have reliably learned that there's some correspondence that he did not refer to, which might be more relevant to the proceedings of today. Namely that some members of this committee who are not able to be here have already had indicated that they will not be here, and that they are engaged elsewhere outside of the country, on the basis that there were not going to be sittings to this week. I don't know anything about it. I'm just saying that Chair, I'm sure you can respond. It's your committee, not mine, but I'm just placing this on the record, that it might not be appropriate if certain political parties are excluded from this important meeting. And my understanding is that the political parties that are represented not by many members, but by one member, would then ipso facto be excluded if those single representatives are not here. And the persons who are overseas and unable to come, Mr. Brett Heron, whom I understand that returned to the committee to ensure that the meeting does not take place today. He is from the Good Party. Another party that's also represented by one person is General Holomisa, is also not here. And then the FF Plus, Dr. Mulder, is also not here to represent this party. And the member from the Economic Freedom Fighters, that's Ms. Mpile Mautwe. All of them represent parties that are only here by a single representation. So I'm just putting it out there, Chair, for the record. I'm sure you might have dealt with it administratively elsewhere, but I just wanted to be recorded that it would be preferable if every party at least participates in this proceedings of today. But Chair, I don't know if you may want to deal with it now or at a later stage or not, but that's...
No, please proceed. I will deal with it later.
Okay,
Thank you.
thank you, Chair. Right. Well, then on that basis, then, Chair, I will proceed on the assumption then that the meeting is still properly constituted, even subject to what I've just said. All right. Now we can start with this with the clock. Thank you, Chair. Chairperson, I'm going to try and tighten this, as you've already indicated. The application, according to the directives that you gave us on Monday, we had to submit the application yesterday. And I'm assuming, as you have indicated, that the purpose for that was for the members to familiarize themselves so that we can all then tighten the proceedings rather than going through word for word what is there. So if I leave out anything that is in the document, please, it's not because it is being abandoned. It will be because either we have run out of time or we have prioritized it in a particular way. Yeah. Now, let me start right at the first page of the document. We have submitted. Okay. I think I'm being recorded to some other headquarters. But no, that's fine, David. We've submitted, Chair, as you've indicated, a 24-page document, which constitutes the application, because the directive 10.2 says any person wishing to make an application to the committee, which is not otherwise provided for in this procedure or in the assembly rules, must do so in writing to the chairperson. So in compliance with that directive, we submitted the 24-page document, and I'll be speaking to that document. You also, in your directives, this on Monday, you directed us to then file the notice, because at that stage we did not have firm instructions, by Monday, which we did, and also the application by yesterday. And we apologize for there was an hour's delay in the submission yesterday. Chairperson, you will also have noted that both in the notice and in the document we sent you yesterday, we indicated that there are in fact 2 applications. But for the sake of word economy or efficiency, we've combined them into one so that we don't have to bring 2 piecemeal applications. And they are, because they relate to the same process anyway. Those 2 applications are, in the first instance, and what we might call the main application, is the application for the recusal of yourself, Chairperson, as the chairperson. And the second application is the recusal of Honorable Kevin Mileham, who is a member of this committee. And as I say, there are 2 separate self-standing applications, but we have agreed, or at least we have proposed, and there's been no objection that they be moved together. Right. So what I will then do, Chair, just in terms of structure, I'll make some broad remarks about the application, situating the applications in the legal context in which they take place. Then I will deal with the two applications in turn, starting with the recusal application of the chair, and then more briefly, because there are fewer grounds relied on, deal with the application for the recusal of Mr. Mailham. And then thereafter, I will address the meeting on some of the principles, legal principles that are applicable to an application of this kind. The other thing, Chair, is that I'll try to save time, because I will request you at the end to give me a few minutes to reply to whatever might have been put by the evidence leaders. But I'm saying a few minutes, Chair, because some of that response would have been covered anyway when the members ask questions. So I want to waste time and cover things that would have been covered by the members when they ask me for clarity or whatever at the end. Thank you, Chair. So then if I can then proceed, Chair. The starting point is this. This committee is bound by various legal instruments that govern it. At the most basic level, it would be the directives. The directives, after all, are directed at this particular committee. So there may be another impeachment committee to have its own directives and so on. So the directives are custom made for this particular committee. So that's really the starting point. Then, of course, the directives and the committee are products of the rules of Parliament. And so that's the second important instrument which will then bind the work of this committee. The rules, particularly Rule 129. 129Q to Rule 129AF. Then the next thing then, Chair, is the empowering legislation, which establishes the Parliament itself, in terms of which the NA rules themselves are a subject, and that cluster of legislation includes the Powers and Privileges Act. And then most importantly, it's the Constitution of the Republic. All those instruments and sub-instruments and what have you are nothing if they don't conform to the Constitution, because they would have been then invalid as a matter of law. So if you like, that's the regulatory framework in which this application must be viewed with those instruments in mind. Now, if you zoom into the rules of this committee, the most important rule for the purposes of this application is Rule 129AD2. And for that reason, you'll find that in paragraph 1 of our document. Rule 129AD2 simply says the following, and I've quoted it here before, so I won't explain much. The committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time frame. Now, that instrument really is the Bible, should be the Bible for the committee. And it covers three things: reasonableness, a reasonable time frame, that's the practical side of it, but most importantly, procedural fairness, which is really what today's discussion is mostly about. Then, Chair, before I get into that, I want to say this. I think it's very important also to situate our discussion. I will refer to you later to case law that says that a recusal application is not something that should be done lightly. Like every time you're unhappy, you do a recusal application. That is something that it must be done as a matter of last resort, and we will demonstrate that we have really done that more than the call of duty. We have made several warnings here that things were going in a particular direction. We have issued sounded many warnings. You'll remember on the 26th of August, with your permission, Chair, I addressed the committee for about half an hour when we were concerned about certain conduct on your part. And if I can't remember the words I used verbatim now, but I know that in the media, they said I had asked for your recusal, but I had not. I had specifically said that if these things are not addressed, we would consider an application for your recusal or removal. And that was, again, an effort to try and get things back on track, because we were under some impression that that could still be done. Again, on the 13th of September, I did say that things might escalate to this. You might not have liked the language I used when I said the day will come, but that day has come now. And all that was really in an effort to try and avoid this situation. We know there was a hullabaloo and fake outrage about those warnings, but they were sincerely meant to say, let us try and avoid this moment of having to ask for a recusal. And it was in the spirit, Chair, as I say, of our understanding that a recusal application is not something you just jump into every time you disagree with something. You must do your utmost to avoid it. Otherwise, proceedings can just be unnecessarily interrupted. So even when there was serious provocation, we indeed tried to avoid it. And I have to say this, Chairperson, for the record, that actually, when you were shouting us down and all the things I'm going to talk about now, you were doing what is literally called shooting the messenger. As far as our client is concerned, the public protector, the moment at which this application should have been brought happened a long, long time ago. She was uncomfortable with some of the things that happened in this committee as far back as in July. And it was the legal team led by me that persistently insisted and persuaded her that we had not reached a point of no return on several occasions, including that occasion on the 26th of August. The reason I used that careful language was because I had to mention the intention to recuse, but also express the view that it was not something that was happening there and then, as it was wrongly reported in the media. And I think it's important to place that on record. So it was only when things reached a stage where we could no longer persuade the client that her impression about the inherent bias in this process was wrong. in a way, she won that battle because we kept on saying, no, we have not reached that point until we learned the hard way last week that maybe that point had not only been reached, but it had actually been exceeded. Now, with that background, Chairperson, let me then get into the meat of the application. We have referred you already to Rule 129 AD, which 82, which prescribes that the committee must operate according to, among other things, the standard of fairness. There's also an issue of reasonableness and transparency, which are raised in that rule. And the basis of this application is that the chairperson has breached all those three standards. And the main basis, as I've indicated, is that the compulsory standard of fairness, which is not negotiable and is not something we ask for, as we said earlier, as a favor. It is something that we are legally and constitutionally entitled to a fair process. That is why in the past 2 years, we have gone up and down the courts and succeeded to affirm or win the right to fairness, including the right to legal representation. And the Constitutional Court has confirmed that we are legally entitled to that right. Now, fairness is as I say, it's difficult to define, but it's easy. Everyone knows when unfairness is being visited upon them, or when injustice is visited upon them. But it is a matter that the legal scholars have defined in the way that I'm going to get into now. A procedural fairness in particular is founded in two common law principles, Honorable Chairperson, which are known as the rules of natural justice. Those two rules are, and I think I've said this before, I've got an aversion to using Latin, but sometimes it's not avoidable. The first one is commonly known as aude alteram partem. That's known by people, even non-lawyers. And it simply means that the other side must be heard. That's a fundamental rule of fairness. If you don't observe that rule, you can't say a process is fair. The second rule is called nemo iudex in rem sua. It just means nobody can be a judge in their own case. And it's the rule against prejudgment or predetermined outcomes, those kinds of things that we have spoken about before. It's commonly known as the rule against bias. And that's the one that we want to emphasize today, with the proviso that the two rules of natural justice are not separated by Chinese walls, so to speak. They overlap.
Okay, apologies for that. Please mute yourself, Honorable Msimang. Proceed, Advocate Mbofu.
Thank you, Chair. I was saying the two rules overlap. Ironically, that the overlap between the two rules was established by the Constitutional Court in a case that involved the public protector, which is part of the cases, one of the cases that feature in this committee. That's the case that deals with CX, Chair. Yeah, in that case, you might remember that the majority judgment of Chairperson established the view that sometimes, or not sometimes, particularly in that case, you'll remember there was this whole thing about whether the Reserve Bank had been given audience when the public protector had meetings with the agency or the president or the presidency. And the court there found that a denial of the right to hearing may lead to an inference of bias. And so the court found that in that case, the public protector had been biased purely because she had not given somebody a hearing. So that was the most classical overlap of the two rules. In other words, they were saying by denying Audi, you may be inferred to be biased. And as a result of that, that court then issued a personal cost order against the public protector. Then we will also rely, thirdly, Chair, on another format of fairness called the doctrine of legitimate expectations. Fortunately, that one is not expressed in Latin. Yeah. But again, to just simplify that doctrine, it simply means that when there are certain situations where a person is entitled legitimately to expect fairness arising from various instruments, either arising from practice. So, for example, if, let's say, Chairperson, whenever we come here, there's a lunch break and so on. And then one day you just decide, no, we're just going to go ahead. There'll be no lunch break. Then we're legitimately entitled to expect that there will be a lunch break. I'm just simplifying it so that it's not complicated. But again, it's something that all human beings, you don't have to be a lawyer, you'll know that. If your parents always allow you to come home at 6 and then one day they say, you know, you must come home at 4, you might say, well, you created the expectation that I'm allowed to come at a particular time, but now you're changing the rules midstream, so to speak. So it's unfair in the literal sense of the word. So those are the three bases then, Chair. It's Audi, it's Nemo Udex, and legitimate expectations. Those are the three grounds on which both the applications against Honorable Janchi and Honorable Mileham are based. If we can then come to the Chairperson's applications more specifically. This one, I'm going to try to manage it because of the time factor, Chair. We have set out in the document 12 grounds for the recusal of the Chairperson. Each of those grounds, I have to say upfront, is sufficient to base the recusal application. So there must never be a notion. There must never be a notion that says that if we show 6 of the grounds, or if you agree with 6 or 3 or 2 or even 1, then it means that, because there is that kind of logic which has been applied even in this committee, that it's about numbers. Yeah. So if you have 10 grounds and then you get 2 or 3, then it means that no, it's not like that's not like football. So even one of those grounds is sufficient in its own right. In fact, Chairperson, to be honest, we could have put 20 or 25 grounds, but we just had to cut it at some point and take the most important grounds. And you'll be happy, Chair, from a time management point of view, that I'll cut it even further down by doing what I propose to do now. Maybe before I even do that, if I can just point out some typos. Unfortunately, these documents were done under tremendous pressure. So we noticed some of the typos. One of them is relevant to what I'm dealing with now. It's on page 6, paragraph 20. where we talk about, we say we raise the primary grounds dismissed in sections B1. It should be discussed, not dismissed. Primary grounds discussed in sections B1 to B12, not to B2. Thanks. Thank you, Chair. Let me just do the others now so that we don't come back to that. Paragraph 29, you'll see that it says the issues related to section B3 above, should be below. And then paragraph 30, certain scathing remarks. Okay, this one is attributed to my PA. It should be scathing remarks. And then, of course, paragraph 31 is not Honorable Heron. It's Honorable Heron. So that I is supposed to be double R. And then paragraph 33, it says there are innumerable examples. There's no such thing as innumerable. Should be innumerable. So the first syllable there is I. Innumerable. And on page 8, I'm sorry, paragraph 80, Chair. It talks about biased and improper subpoena. It should be suspension, not subpoena. Right, thank you. If I pick up anything else, I'll indicate. Right, so back to paragraph 20, which is where we are now. I'm now saying then, Chair, I'm going to try and arrange the discussion of the 12 grounds. As I say, I want to emphasize that these 12 grounds, which we have nicknames the dirty dozen. These 12 grounds, only one of them is sufficient for this.
You have nicknamed it?
The Dirty Dozen.
The Dirty Dozen.
It's after there was a movie, it was before your time, Chair, which was called the Dirty Dozen. Yeah. Only if you were already going to the movies.
I'm glad I've never watched that movie.
Yes.
Go ahead.
It's a good movie, Chair, but it was made in the 70s, yeah. Or even before. So that's just to indicate that it's a dozen reasons that we rely on. Now, what I'm going to do, Chair, then to try so that, because we don't have time now to go over a dozen reasons one by one. So I'm going to do it like this. Reason B1, if you go to B1, it's called the scope of the inquiry. And if you go to B5, which you'll find at page 11, it's called undue comments and interference in the High Court litigation. Then B6, Chair, is rulings related to cross-examination and re-examination. And then B7, which you'll find on page 13, is rulings related to the concept of relevance. I will start with those, Chair, very briefly. The reason for that is because these are matters that we have already canvassed in the committee at different points. So I'm not going to belabor them. I'm obviously raising them now in a different context of a recusal application, but these are matters that are known to all the members, and also, so I don't have to waste time on them. I'll just literally get them out of the way, so to speak. So B1 is the scope of the inquiry. That is the issue, Chair, that we started with on day one on the 11th of July regarding the inherent unfairness in expecting the public protector to deal with those matters that have effectively been ruled by the independent panel not to constitute prima facie evidence of any wrongdoing. And we do this, Chair, mindful of the very first thing that we all had consensus on day one, that this is a pioneering process, something that has not been done before. We're all trying as much as we can to to find a pattern and hopefully to set pace for the country. But our view, Chair, is that it simply doesn't make sense to have a whole hullabaloo about an independent panel which must sift the evidence and explain whether there's prima facie evidence, and then just revert back to investigating things, even things that they have specifically said there's no evidence, prima facie evidence on. It just doesn't make any logical sense. From a practical point of view, from a time management point of view, from a financial point of view, from a legal point of view, it just doesn't make sense. And the insistence on that has led to all sorts of witnesses being called and led on total irrelevancies, and wasting the time of both the committee and the public protector. But it has also led to other inherent unfairness, because certain evidence that gets led because of that is prejudicial completely. And I'll refer later, for example, to the flighting of statements and letterheads of our attorneys, which is just gratuitous and doesn't serve any purpose. And it cannot inherently serve any purpose if it's something that's outside of the independent panel's ambit. So the only thing we achieve by doing something like that is just to prejudice people without any gain whatsoever, because the gain is zero, because it's irrelevant. It's got nothing to do with this committee. And if I may say so, already that has been experienced, sadly so. Last week, there was a fraud that was committed in respect of a payment that was being made to Mr. Sianego's firm by the Public Protector's Office, where that was diverted by some fraudsters into some account. And they had put a fake letter under his letterheads, directed it to the Public Protector's Office, and they paid money into the criminal's account, and it's now being investigated. And we are convinced that those fake letterheads were generated as a result of the gratuitous display of Mr. Sianego's details here. As I say, if that had to be done, it had to be done. Let's assume there was some value that we could get from it. But when there is no value, the only real reason is to, or rather raise outcome or value that we can get from it is just criminality, then it boggles the mind why that would be allowed. I then move to and we then say that a reasonable apprehension of bias is generated by that, because apart from the criminality, the only other basis to do this is just sensationalism and media hype and all sorts of noise to try to paint the public protector in a particular light in respect of things that are not before this committee, quite frankly. So if anyone wants to go and insult the public protector or call her names, you can go and do it out there, but we shouldn't use this committee as a conduit for such totally valueless so-called evidence. Right, then we jump, Chair, to B5. B5 is the issue of the undue interference by the chair in high court litigation. The reason I will not address that is because, as I say, on the 26th, you kindly gave us half an hour to deal with that, and we dealt with it, and we addressed the committee. Again, just to emphasize that we're including it now in the context of a recusal application, but it's still the same thing. So we're not going to repeat what we already said to the committee. That really had something to do with the irony of the chairperson sitting here as supposedly a neutral chairperson. And then while outside, in our humble view, at least, writing to the High Court to try and influence litigation which is related to this committee, and also celebrating, well, maybe I'm exaggerating that, but at least agreeing that the public protector should have been mulcted with personal costs, when that was such an unfair outcome anyway, because she was not given an opportunity. All she was asking was, how did information leak from the Constitutional Court? And for that audacity, she was mulcted with personal costs. We can't do anything about that, but we can do something about the chairperson endorsing such an injustice. Then there's B6, Chair. B6 deals with rulings related to cross-examination and re-examination. Again, we've raised that before. A ruling has been made. We're raising it now. But just in a nutshell, what that means is there are various rulings, as you know, which were made here relating to cross-examination. Firstly, our cross-examination gets curtailed. Secondly, the time granted for the cross-examination is insufficient and is actually dependent on the evidence leaders. If the evidence leaders want 2 hours for a witness, then we also get 2 hours. If they want 3 hours, we also get 3 hours. So that's inherently unfair. I've indicated here that cross-examination by definition is longer than leading a witness. But if we can't even get, if in fact in one instance, I think it was my friend, Ms. Mayosi, who said, I need 3 hours. And then, so if she needs 3 hours, then it means we'll also get 3 hours, not what we need, it's what they need. So that's the one thing. And then, of course, we have been denied the right to ask questions after the members have asked their questions, which is also inherently unfair, because questions that arise from the members or from the chair, for that matter, in any forum that I've ever been to, are then subjected to questions by the parties. When I say parties, I don't mean it in the formal sense, but we should, if the chair raises certain questions from a witness, for example, what should happen is then to say, arising from my questions, is there anything that the evidence leaders want to say? And then they put their questions. Is there anything the public protector wants to say? And we've asked for that right, it was denied. And that is inherently unfair. The last issue with cross-examination has to do with what I can only describe as the shocking conduct of what happened in the case of Mr. Muntu Sithole, who was blatantly cross-examined. And it didn't matter how many times we pointed out that a party that is called a witness cannot cross-examine that witness. And secondly, in any event, the evidence leaders are not entitled to cross-examination at all, according to the rules of this committee, of anybody. But I think it took the witness, who was fortunately also legally trained, to say, maybe for other people to understand that's what was happening to him. He was being cross-examined. And that was what we call an egregious violation of the directives by the chair in allowing that. Despite our protestations. And we say at paragraph 48, the chairperson's ruling to the effect that the questioning did not amount to cross-examination cannot withstand any objective scrutiny. It was also correctly refuted by the witness himself, who's a qualified attorney and whose evidence was credible, balanced, and exemplary in general. So that's B6. B7, Chair, as well, relates to issues of relevance. This one really is just, it's exhausting to even talk about it. So I won't be long on it for that reason alone. There is clause 6.1 and 8 of the directives, which is very clear, and we've read it out to you, Chairperson. 6.1 simply says that all questions put to witnesses must be relevant. Maybe we can put it up. It's an annexure to the application. No, have you got it? Yeah, no, I wanted to put up the 6.1 of the directives. So, oh, there it is. Sorry. I don't have my glasses. This is when I get confused because I can only read farther and near here in front of me. Okay, 6.1, just for the sake of progress, says all questions put to witnesses must be relevant to the assessment of the motion. So even if you were, forget about the thing about whether it's the narrow or the broad one, even if you take the broad one, it must be relevant to the assessment of the motion. Disputes regarding relevance shall be determined in accordance with 8. And then 8 tells us what needs to be done. Only questions, evidence, and submissions relevant to the issue of incompetence or misconduct as alleged in the motion shall be asked, led, or made during oral hearings. Can't be clearer than that. In other words, all this stuff that we've listened to here about labor and human resource grievances and whether there are about 15 witnesses who were called to tell us about their own views about how deadlines should be met or not met and what have you. You know, all of that, some of the witnesses were only called like this one, who's understand now, to deal with those things without any visible, I mean, except for contrived references to the motion.
Maybe just a pause there.
Okay.
I see the hand of Honorable Mahau.
Okay.
You have your hand up.
No, sorry, Chairperson, it was pressed by mistake. Sorry.
Okay, all right, thank you. Proceed, Advocate Boff.
Thank you, Chair. Okay, anyway, I wanted to move from that. So the idea, Chair, of allowing, as I say, some evidence which may even be prejudicial, well, not which is prejudicial to the rights and interests of persons, on the basis that, as you put it, Chair, when we raise those issues, at the end of the hearing, then the members will have to work out if they can even remember that, oh, witness number 12 said something which may have been irrelevant and therefore it will be excluded, by which time that thing would have been floating in the public space for 2 months or 3 months, you know, and then it might be outruled sometime in November or December or January or whenever we finish, when it has been bandied about in the public space for months and months. It should be clear to anybody that that is the rule. That rule was meant exactly to prevent that, basically, and it's flouting in this committee is can only be a product of inherent bias, because anyone should understand that the standard of relevance is meant to basically keep everyone in check, so that, because otherwise we can all come here and tell our life stories on the basis that later they will be excluded. But that can be what this inquiry is all about. So those are the 4 grounds, Chair, that I wanted to start with, so that we get them out of the way. Now let's get to the main grounds for recusal. And forgive me, I'm going to sound like a broken record, but I have to repeat this. That even on the grounds that we have dealt with, which emanate from previous discussions, the reason why I'm dealing with them quickly is because they've been dealt with before, not because they are lesser grounds. And they themselves are sufficient, in my respectful submission, to form the basis of a recusal. The grounds that I do want to address in slightly more detail than Chair start at B3, B2. And that is a ground that deals with the unlawful and unilateral amendment of directives and misapplication thereof. Again, Chair, you'll be happy that the part of this has been addressed before, and so I won't dwell on it much, except to say this. On the raw facts, this is what happened. We arrived here on the 11th. The directives were in the making. We were at that stage actually in consultation with the evidence leaders because we had hoped that we could have the directives adopted by consensus. It became clear that that consensus was not going to be achieved because the issues that we raised here on the 11th were not listened to, basically. And as you are entitled to, then Chair, you intervened by effectively imposing the directives on us because they could not be put in by agreement. And we explained at that stage that, you know, because we wanted the process to get on, basically, that despite our objections, we would operate in terms of those directives. That was on the 14th of July, 2022, when you signed them. Then certain things happened, particularly around witnesses that did not finish their evidence. Mr. Pillay, Mr. van Lochenberg, and I think Ms. Baloyi, where we indicated that we would need them to be recalled. And there was an understanding that that is what would happen. And I don't want to elevate it into anything higher than an understanding. But out of the blue, on the 26th of August, we were told that there's a new directive or so-called amendment or addendum, which I can put it up at SEPA. I think it's the first annex chart to the application. RA1. The application is item 27, bundle H. Yeah, there you are. No, that's the directive. Can we go to the addendum, RA2? Yeah. So right in the middle of the process, on the 26th of August, 2022, we were told that there's something called Addendum 1 to the amended directives, whatever that means. And it is directions on the recalling of witnesses and amendment to the directive 5.9 is issued by the chairperson, and so on and so on. The long and short of that directive was to now impose a whole lot of, let's go to 6A, yeah. 6A1, 6.2A, Roman 1, Roman 2, Roman 3, Roman 4, 6.3, 6.4A and B, a whole long thing about curtailing the recall of witnesses. Now, there are two objections about this, Chairperson, which point to both a breach of the rules of fairness and the rule against bias. In relation to the rules of fairness, you can't impose you can't have a process and then somewhere in the middle of it, you impose rules or change the rules as you go along, you know, that's just wrong on its own. But more importantly, you can't, if you do that, in those exceptional circumstances where you might be allowed to do that to cater for, let's say, an unforeseen situation or whatever, then that rule cannot be made to operate retrospectively. That's just a fun, again, these things, fortunately, anyone with a sense of fairness, as I say, will just understand them. In other words, you can't just say, okay, let's assume the rule was put on the 26th of August, but why should it apply to Mr. van Lochenberg and Mr. Pillay and so on, in respect to who have already testified? It might be allowed to apply to witnesses going forward. As I say, even that might be wrong, but for different reasons. So that was just a you know. Also, you can't legislate for a particular person, so to speak, because had Advocate Mkhwebane not asked for the recall of Mr. van Lochenberg and Mr. Pillay and Ms. Baloyi, that addendum would not have been there. You wouldn't have just woken up on the 26th of August and decide to have an addendum. That addendum was there specifically to respond to her request for the recall of those particular witnesses. It's what is known in the South African context as the Sobukwe clause, where the apartheid government passed a law particularly for a particular person. Something like that is inherently unjust and unfair, because when you pass directives, they must be for general situations which will apply forever and to any other person, not a law that is specified for a so-called Mkhwebane clause, as it were, or one that is directed at a particular request for particular witnesses. Again, that's something at least any student of South African history would know, that it is inherently unfair to have a Sobukwe clause type of legislation. And it's an exhibition of bias. Only very few people in the country would deny that the Sobukwe clause was inherently unfair. You don't even have to justify that. So that's what's wrong with the so-called addendum to the amendment, whatever it's called. Then we go to B3, which you'll find at page 8, Chairperson. This is, again, a matter that we have dealt with before, the refusal by the Chairperson to subpoena Mr. Cyril Ramaphosa. We have said that, I'll just read it out so that we don't waste time. In August 22, the Chairperson refused to request the Public Protector to be assisted in securing the relevant evidence of Mr. Cyril Ramaphosa, who had made certain scathing remarks, not skirting, against the Public Protector, which form part of the impeachment motion, with particular reference to the so-called CR17 Busasa litigation referred to at paragraph 11 of the charge sheet or motion. And then we say, in the process, the Chairperson unfairly and unreasonably rejected the proposal made by Honorable Heron to seek further information from the Public Protector regarding the relevance of Mr. Ramaphosa's evidence. And this is information we got from your letter to us. And say, in so doing, the Chairperson acted unreasonably, unfairly, and in a manner which exhibited manifest bias against the Public Protector and in favor of Mr. Ramaphosa, who is also the President of the African National Congress, of which the Chairperson is a loyal member. That part we're just guessing. And then we say, what's important about this, Chairperson, before I expand, is the following. That ruling is actually in conflict with your ruling on the scope. Let me explain. According to the scope ruling, you said you are bound by the motion of Ms. Mazzoni, as it is, line, hook, and sinker, or whatever the correct expression is. And you can't do anything to it. Now, the motion of Ms. Mazzoni contains the references to the CR17 Bosasa matter. And those matters are specifically taken from remarks made by or on behalf of Mr. Ramaphosa in court papers. So Mr. Ramaphosa and Mr. Van Lochenberg or Pillay in that situation are in exactly the same position, because the only reason why Mr. Pillay and Van Lochenberg were called here is because they also had made certain remarks under oath against the public protector, which were then, they were brought here. So it's impossible. I mean, it's just completely illogical. You cannot say in the same breath that Mr. Van Lochenberg and Mr. Pillay are relevant witnesses, but Mr. Ramaphosa is not. It's just, it offends every fairness bone in any, it should offend in anybody's. Actually, to be honest, it's Mr. Van Lochenberg and Mr. Pillay are peripheral witnesses, because in the cases where they were called to come and testify here, it was Mr. Godan who was actually the main person. But Mr. Godan was not called for all sorts of reasons that we can only guess. And only the other secondary people who had made those remarks were called. Fine, that's not our business. That's a business of the evidence leaders. If we want Mr. Godan to testify, we will subpoena him, as we intend to do. But I'm making a different point now, which is that it would have been impossible to have either Mr. Godan, Mr. Pillay, or Mr. Van Lochenberg to be relevant, while the person who did exactly what they did, which is to put affidavits that in respect of which the public protector has now been impeached, and then we're told that that's irrelevant. That's number one. Number two, we have noticed with interest that the evidence leaders have, since we raised this issue, stayed away from any evidence to do with the CR17 or Bosasa matter. But that's irrelevant. If that is meant to dissuade us from the relevance of this evidence, well, then it's just a waste of time. Because, as I say, you can't have your cake and eat it. It doesn't matter whether the evidence leaders lead evidence to do with CR17 or not. The fact is that it is in the motion. So if it's in the motion, the evidence leaders have no right, quite frankly, to not to call witnesses in relation to any part of the motion, and by that amend the motion of Ms. Mazzoni. I'm not saying that is what they were intending to do. I'm simply saying that to the extent that they have not led evidence on CR17, that changes nothing about its relevance, because it is in the motion. So you can't say, no, I'm taking the motion as it comes originally, and then when it suits you, say, no, I'm only taking the motion as far as evidence has been led, just all in the effort to save Mr. Ramaphosa from just coming to assist the committee about the remarks that he made under oath. So that's clearly a matter of bias. But what is worse is that, unfortunately, when we drafted the document, it was in the morning. After that, there was a judgment that came yesterday, which underscores this fact. Because in that judgment, you will see that one of the things that is raised is that people like Mr. Ramaphosa, who have raised money in order to run political campaigns, are now required as of law to make a disclosure in terms of the Executive Members Ethics Act, in terms of the law of those donations. And therefore, if they don't do that, then the judgment says openly that this is a measure that is intended against corruption, which is what it is, to conceal money that you are benefiting from. And that we know that, Chairperson, if you read the judgment, it's not a long judgment, that is traced in section 96 of the Constitution. And that section, I think I've said this here before, or I don't know if I said it here or said it in court, but that section is what distinguishes members of the executive from you and me. You and me must also not be biased, which is why I'm making this application. But members of the executive, on top of whatever governs you and me, have an obligation under section 96 of the Constitution not to place themselves in situations like such as the CR17 situation. That's what the Constitutional Court said yesterday. And it cited section 96 specifically, and it cited the Act specifically. So how can that, now, we know that the so-called remarks that were made against the public protector in relation to CR17 is because she also agreed with that approach. She said, if you are a member of the executive and you receive money and it's going to benefit you politically, then not to disclose it is corruption or maladministration or whatever. I can't remember what was said in the report now. And Mr. Ramaphosa's defense there was that, no, this has nothing to do with him being a member of the executive. It's some private thing in the political party and so on. Well, yesterday's judgment shows that is a fallacious argument, albeit it is going to apply going forward and not retrospectively. But the point I'm making, Chair, is that that is in the heartland of what this committee is examining. It's not whatever the courts have said. It is whether the public protector, in taking the view, which was confirmed by the Constitutional Court yesterday, should be impeached. Because if she should be impeached for saying that if you get money and it benefits you politically and you're a member of the executive, that is maladministration, then the entire Constitutional Court should be impeached as well. Because that's what they said yesterday, exactly what she said. Apart from the fact that we should be grateful to the public protector for having taken that stance, because had she not initiated that litigation, had she not opposed that litigation, we would not have had the judgment of yesterday, which develops our law and our anti-corruption efforts in this country, takes it to a step further. But forget about that. We don't expect anyone here to praise the public protector for anything. But at least let's agree that we don't condemn her for saying the same thing that was said by the Constitutional Court, 1. 2, let's also agree that that debate is irrelevant to the work of this committee. That's all actually that we need. And your refusal to understand those simple basic facts which emanate from the motion itself in our respectful submission is not a coincidence or a lack of appreciation of the relevance. It's simply pure bias and a desire to pander to Mr. Ramaphosa and whatever other largesse he might be able to offer. And that is not a sign of an impartial mind. And I might say here, we have referred before, there are foolish people who say that a minority judgment is not something to be even considered. Well, that's not true. Lawyers know that we say minority judgments of today are the groundbreaking judgments of tomorrow. And that is what has happened here. Because in the case of CR17, Justice Mogoeng had said that it's fallacious to distinguish between the benefits that one gets in the way Mr. Ramaphosa got. And he's now been proven right, at least to that extent. But that's a story for another day when we deal with the merits. For now, we're still just dealing with the recusal application and the illogicality of the ruling made here, which can only be ascribed to bias. Then, Chair, if we then go to B4. Okay, B4, it's called unduly favoring the evidence leaders and the unwarranted proximity to collision with them, and generally adopting an opposition posture towards the public protector and or her representatives. Well, this one we can go on the whole day, so I'll just try and cut it down. That's where we said that there were innumerable examples of such conduct, but we've put a few of them. And that include the chairperson rejecting almost all objections by public protector, including those that have referred to dealing with relevance or cross-examination, but dealing differently when the similar objections are made by the evidence leaders. And we make an example there of the objection of the evidence leaders pertaining to the allegations of sexual harassment against him by Mr. Ndo. Sorry, I didn't put the name there, but that's what we're dealing with, which the chairperson ruled to be relevant in respect of his and other testimony. This was the most blatant example. Here we have been pointing to the chairperson that the certain evidence, either in whole or in part, was irrelevant. And we're told, no, you must wait until one day in November or December when it might be excluded. But for the first time, when the evidence leaders wanted evidence to be excluded, the whole attitude then changed. The chairperson not only ruled that that evidence must continue, the chairperson actually stopped the proceedings and called for a meeting of the committee and so on, and then came back with a ruling. None of that had happened before. Our objections just get rejected out of hand. And that was the purest exhibition of bias on your part. Now, and then we've already spoken about the duration, which is now determined. Cross-examination is just determined by whatever the evidence leaders want or need or whatever they say. Yes, we've made all the other. Oh yes, this one is very important. We have at least tangible evidence of this, because when we wrote to you about the postponement last week, for example, you responded to us and gave us a 4 or 5 page letter, which included in it discussions that we had had exclusively with the evidence leaders. Now, I'm not saying that they're wrong by conveying those discussions to you or whatever. I don't know what the actual relationship or how the workings are on that side. But to the extent that I've ever been an evidence leader, or initiator, the relationship is hopefully arm's length, and I have no doubt that my learned friends know what that is. But that's not the point. The point is, when we are having discussions with the evidence leaders about a matter which affects the public protector in particular, we can have discussions about anything else. But we can't then, those discussions find themselves in your correspondence to us, which means they were discussed in our absence, a matter that affects us. It's one of the most basic rules of fairness that a person in your position, chairperson, cannot have those kinds of, it's improper to have those kinds of discussions with one of the parties, quote unquote, in the absence of the other. And let me pause here, because I don't want to listen to, unnecessary lectures about that, no, there are no parties here, or there's no the evidence leaders don't have a case to close or whatever. I'm not at that infantile level, or even that to say that this is not a court of law. I know it's not a court of law, so please spare me that. Yeah. So the fairness is fairness, whether you're in a court of law or on top of the roof or whatever. What is unfair is unfair. Yeah. So when I make examples about fairness of a process or a court process and so on, if I don't know by now at my age that this is not a court of law, then you might as well not say it, because it means I will never understand it. So the point that we make is that fairness is a standard that cuts across all sorts of processes. And you know when you're doing something that's unfair. It doesn't matter if it's at a lechutla under some tree in the village, or whether it's in a formal court sitting, or indeed in a process such as this one. There are certain basic things. You cannot discuss matters that involve one of the participants, let's call them that, instead of parties, in the absence of the affected participant. It's just simple. So that, as I say, we have concrete evidence of that having happened, because how else would you have put in a letter things that were discussed bilaterally between us and the evidence leaders, except if you had a discussion with them about that matter, which we discussed with them, which affects the public protector. Then we talk about what we call unidirectional hostility and negative remarks directed only at the public protector and her team, while not censuring the same conduct on the part of evidence leader. And we say this includes the undue levels of impatience, shouting at, and suppression of the public protector's legal representatives in violation of the clear ruling of the Constitutional Court. This is a serious matter. The shouting and haranguing and all that, is water on a duck's feather. We don't particularly care much about that. I've said many times here that please don't shout at us, Chairperson. And for that, I'm the one who was told that I should not. I don't know what I must do. So I should be shouted at and demeaned, and I must lie down and play dead. And I think I've made it clear that that will never happen. But be that as it may, I'm not the chairperson. The chairperson own impatience, shouting at us, and suppression of what we have to say is an exhibition of bias, because we've never seen that being done to anybody else. And then we've said that there was instinctive rejection of proposals unless they are supported by the evidence leaders or a member of the committee. And that is actually, I'll make a classical example of this. Happened, it's a pity that Honorable Heron is not here. When Mr. Pillay was testifying, I said to you, Chairperson, there's somebody whispering to this witness, which is a serious matter. And that was dismissed. It was only once Honorable Heron said, I heard it myself. There's someone who was whispering there, that the matter was attended to. So, I mean, if that's not bias, then nothing is, because why do I need to be, what if Honorable Heron had not heard the whispering and I was the only one who had heard it? Then it would have been, some alleged madness or whatever the media is wont to say, which I don't care much for. But this is just an example of the inherent bias in just dismissing anything that we say. Then I've made a reference to for lack of a better word, again, I don't want to elevate it. I call it a gentleman's agreement. Sorry for the sexist metaphor. But I just wanted to, I was using that because I didn't want to elevate it to what it is not, because there was no agreement, a written agreement or even verbal one. But there was certainly an understanding, maybe that's what we should call it, an understanding, Chairperson, that we would need, after the last witnesses called by the evidence leaders, we would need a period of 2 weeks to put our own ducks in a row, to prepare our own witnesses, to decide which witnesses we want to call, and so on. And I had discussed that with you, Chair, and the evidence leaders informally. I admit, that, as I say, there was no protocol that was signed by anyone. But that was always the understanding. And when we asked for clarity on that, when either not getting any answers or we're not getting any, in fact, I think the last response was basically to tell us that we're not going to get that, the fruits of that understanding. Now, that's inherently unfair, Chairperson. Let me explain why. As I said to you in our informal discussions, this is not, let me put it this way. The public protector is committed to having this process speedily done away with as soon as possible, as yesterday, because she believes that this is just a waste of time. There's no impeachable offense that has been committed, and we must just all get on with it, quite frankly, and stop this unnecessary waste of money. But so when we ask for that period, it's not to waste 2 weeks, you know, we have no interest in that. It is only to try and get witnesses. The evidence leaders will tell you how difficult it is to deal with witnesses. And that's why we've been so lenient, not insisting on 7 days, this and that, because we know witnesses have a mind of their own. That's one of the hazards of trial work as opposed to motion work. But this is what we ask for, Chair, in respect of that. The evidence leaders, at least they were appointed on at the end of March. And they've had since then 2 or 3 months before we started the proceedings in July. And therefore they were able to look at the evidence, decide who they're going to call subpoena, who they want to subpoena, and all that in that 3-month period. Decide the sequence of witnesses, who to eliminate, who to call and not to call. And we're saying we don't want 3 months because that would be ridiculous. All we're saying is, can give us a reasonable period, which we have put at 2 weeks, so that we can have the same approach and decide which of the witnesses we really want to call, which evidence implicates them, cut it down. Actually, that 2 weeks would be saving the time of the committee, because otherwise we will call unnecessary witnesses. And so we expected that kind of logical understanding, but it has been unreasonably rejected. And well, to the extent that we can read it, I hope we are wrong about that. So that attitude is also indicative clearly of bias in the truest sense of the word, because as I say, here the evidence leaders had a period, whatever it is, whether it's a month or 2 months or 3 months, within which to do that. And we want not even half of that, or even a quarter. You know, we just want a reasonable period. And the 2 weeks was really for this, Chair, so that we make those decisions in the first week, for example, and then, but we still are able to comply with the 7-day submission of statements, basically. Then, Chair, if I may then quickly go to B5. No, we've dealt with B5. If we can then go to B8. Now, this is an important one, Chairperson, because this one deals with you directly, and is an exhibition of the inherent bias of what the Western Cape High Court called in the latest judgment against the President of the Republic, bias of a disqualifying nature. That's the judgment that was passed by the Western Cape in the Public Protector's matter, in which you were a party. Now, what is bias of a disqualifying nature? And we say you, Chairperson, have made express statements which show conclusively that you have prejudged the issues before this committee. As an individual, as a member of parliament, just as you. Remember, one of the key issues in which around this committee is the issue of incompetence. There's incompetence and misconduct. Now, just tell me, this is what you said, Chairperson, in Parliament. And you'll find that at page 16. Paragraph 15, yes. These are your words, Chair. You said, here we have to budget for incompetence, and you were addressing the Public Protector, Advocate Mkoban. Here we have to budget for incompetence. I will use that word. You said you are being called incompetent, and on the basis of the facts before us, I think I can venture into that. Now, in anybody's language, this was you calling the Public Protector incompetent, which is the exact issue that has to be determined by this committee. Now, even the most naive person who can believe that a person who has said these words can bring an impartial mind to bear to these proceedings on the issue of incompetence, then that person would need their head to be examined. So this is classical bias and classical prejudging. I mean, again, one doesn't have to be a lawyer. Prejudging means exactly this. It means you pass judgment on the incompetence of the Public Protector, and now you're supposed to have an open mind on it. And let's talk about what we call reasonable apprehension of bias, Chairperson. Remember, again, fortunately, you left the advantage of the judgment that was passed by the Western Cape High Court. There is actual bias, and there's a reasonable apprehension of bias. Actual bias exists, we all know that, but it's very difficult to prove, because it's almost like you have to get into the head of the person to show the actual bias. Fortunately, the law has created this issue of reasonable apprehension of bias, so that you don't have to get into the head of the person. So I don't have to say, Mr. Janchi, I know you're biased because I've read your mind, or I've hypnotized you and found that you are. So the test is a reasonable apprehension of bias, and it's articulated like this, Chairperson. Put yourself in the shoes of Advocate Mkoban and ask yourself the following question. Is it reasonable for her to perceive that a person who has passed judgment on her competence cannot possibly be fair or open-minded on that question? That's all you have to do. You just have to be human and be able to put yourself into somebody else's shoes. So it's not, the test is not you or what's happening in your mind or whatever. The test is whether a reasonable apprehension of harm on her part is justifiable under these circumstances. And again, really, I don't think I have to say anything further than that. It's like if I'm going to face, charges of murder or whatever, and then I get a judge, and I find that the judge the previous week said, "Oh, that killer, that murderer, Mpofu, is going to appear before me next week." That's Recusal 101. And it's therefore if you apply the correct test, really the matter should stop right here. That this should be enough to make it clear that we can never get fairness or justice in a process chaired by you when you have said these things. Then I move, Chair, to the issues that are in B9, B10, B11, and B12. And to save time, Chair, if you allow me to those matters are related. And with your permission, I'll address them holistically. These are the matters that I dare say were constituted the last straw for us, and even for me, who has been defending you and trying to argue against your recusal. And these are the matters that happened last week on the 13th of September. This is when I, speaking for myself, then had to sheepishly say to the client, okay, it means you were right all along. And I've now reached a point where we have no option but to agree with you. What happened last week, Chairperson, contrary again to the fake outrage and choreographed noise out there, is shocking for various reasons, not because of the alleged threat, which I've explained ad nauseum, well, insofar as you can call it a threat or a promise or whatever it was, it related to this matter of recusal. And it was, if it was a court case, I would be one of the worst clients, because I would confess that it was not even the first time that I was issuing that so-called threat or warning or promise or whatever I call it. I had done so on the 26th. I did it last week, and it all didn't assist. So that was not that only shocked bigoted, racists and their fellow travelers, about which I don't care. Yeah. It was shocking because we had two grounds, and I listened carefully to your summary this morning. I came here, Chairperson, you will remember, I don't know what was wrong on that day, or what happened to you wherever it happened, because you displayed hostility and impatience of a kind that I have not experienced before. You will remember that actually it started literally on the first minute. You now say here in your summary, you don't want to waste the time of witnesses on things that affect the committee. Well, that's exactly the opposite of what you did on the 13th. We came here, literally, it's just that I don't have time. I could play the video. 9 o'clock exactly, or whenever we started, you said the witness is not here. And there was some technical connection problem or whatever. I said to you, Chairperson, as you know, I'm going to raise a matter which does not concern the witness. Can I carry on with that matter? We don't need the witness for that. No, we'll wait for the witness. Okay. If you want to waste time and wait for the witness, it's fine. I'll wait it for the witness. Then I raised my point. And the first thing I said, again, your summary is distorted, because I said I started with the issue of the public protectors not being well, because I had to. I couldn't just get into the issue about the lawyer's unavailability, because you would have asked me, yeah, that's all very well, but where's the public protector? So I had to start with the public protector's absence and said, she's not here. I have just been informed that she has been taken in ill, And she is for that reason she's not here. You asked me, is that an apology? I said, it's not an apology because I don't even know. I've just been told by a family member myself. I was expecting her actually to come to my office, I think, in that period. And I was told that she had been taken ill by a family member. And from that point on, so it's not true to say, no, there was this issue of the lawyers and then the issue of the public protector came. The issue of the public protector's illness came up front. Anyway, be that as it may, and that's what we deal with at B9. I said, in all honesty, I can't come here and say I'm now asking for the postponement only because the public protector is not here, because that would have been opportunistic. Because as you knew, the postponement was going to be based on the issue of the lawyers, and that is why I dealt with that. What happened there was really what one might call the most embarrassing display of chairpersonship, because the next thing I had to now tell you what it is that I'm going to do in terms of preparation. I don't know what. Yeah. But it should have been sufficient to say there's an urgent application, there's an exchange of documents. I can't be telling you that at 10 o'clock I'll be doing the replying affidavit. At this time I'll be doing that. That's just degrading and demeaning and serving no purpose except to question my integrity, because it can only mean that I was just making it up. Actually, the fact that I have to prepare for an important urgent application. But again, even that, it's not about me. You can have whatever views you might want to have. It's about the client. So that was the first issue. The non-availability, which was explained. And Chairperson, in your summary, I can hear what you're trying to say. You're saying, well, this application was brought by the public protector. Supposedly, therefore, she has no reason to come and ask for a postponement because she should not have brought the application. That's wrong, because I explained to you even on that day that the application, yes, it was brought by her as the applicant, but it had been thrust upon her by the situation that arose from the judgment of Friday the 9th, where in the stealth of night, we received documents from the DA, and on the Sunday, we received other documents from the president. We didn't bargain for that. We didn't ask for it. They did it. They had 15 days in which to do it, but they decided to do it on the weekend. And I had warned about this on Saturday when Ms. Thejane finished, without even knowing that the president was going to enter the fray. So to be now asked here, which comma am I going to put at what time, as if I'm a machine who must just, do those commas and then come and do cross-examination, I can tell you, Chairperson, very few people that work harder than I do. But when I say this is now a situation that is impossible and I need time, you should accept that, well, you don't have to, but at least any sensible person would accept that that is a situation that had been thrown on us. Why else would I ask for time? I don't understand. Then but that again, as I say, it's not about me. You may have your suspicions that maybe I wanted to go on holiday or whatever. But the one that is what I call the proverbial last straw, Chairperson, is when you refused to grant the postponement, even on the basis of the temporary medical unfitness of the public protector. It's only in this country that you can have, as I say, the fake outrage about the so-called promise or threat or whatever, in the face of the harshest display of unacceptable, unlawful, unconstitutional, and patriarchal behavior that we have seen, where I don't know what is the public protector supposed to do if she's sick? Is she supposed to schedule her sickness according to the whims of the chairperson? No, she had a sickness. She did not have to be subjected to that. And even when I begged you, chairperson, to say, here's a medical certificate, I don't want, no, you cannot display it. And now we're told after the fact, which is a bigger insult, that you did that because one, you did not want to interrupt Honorable Gonda, I think was the one who was on the platform. Number one. And number two, you did not want the display of medical information belonging to the public protector. Both of those reasons are unacceptable, to put it mildly. The one about interrupting is wrong, because surely whatever interruption and which if it was necessary, I'm sure Honorable Gonda even would understand that there was a medical emergency. So the two things really don't match. You can't say you didn't want to interrupt a member and therefore didn't accept a certificate. It's just, as they say, using a sledgehammer to crack a nut. So that's the first thing. That explanation, I think, doesn't deserve much more discussion. The second one about the confidential information, medical information, is just a convenient afterthought, which also should not carry much credence, because it was I who represent the public protector who are saying, I want to display the certificate. You must assume that A, I have a mandate to do so. B, I have seen it, at least myself. So I would have known if it details chapter and verse of her illness, and in that case, therefore, violated her. Can you please put up the annexure of the medical certificate? And in the process, the chairperson said to me, what is the nature of the public protector's illness? Well, that question was inappropriate and uncalled for. Firstly, because, well, fortunately, I did not know the nature of the illness myself. So even if I wanted to answer, I wouldn't have answered you. But it's not the answer that I'm worried about, it's the question. So it can be true to say you did not want her confidential medical information to be displayed when you asked me what is the nature of her illness, because that was confidential medical information. As I say, fortunately, I didn't even have an answer. But this is all I wanted to do to you, Chairperson. All. I wanted us to do what I'm doing now. Put up the certificate up there, and it says, this is to certify that Busisiwe Mkhobane has seen Dr. So-and-so on 13/9/2022. She has been unfit for work from 1309 up to and including 1609, signed by the doctor. That's all. It would have taken half a minute, as I've just done it now. But you flatly refused that we should do that to show the members that, so there's no confidential medical information there. There's nothing like that. It just says that she's unfit on those 3 days. I would never, in my rightful mind, put up a certificate that discloses the nature of her illness, which fortunately I don't know even now, and neither is it relevant. So that's and here, if we really had time, I would have put up. You would have just anyone has to do is to just listen to that exchange where I say, Chairperson, I want to put this up, and you shout me down, and I say, don't shout at me. There's no need for you to shout at me. I simply want to put this up, and until I gave up. As they say, the rest is history. So that, Chairperson, if anybody who watches that exchange or sees your conduct and behavior around the issue of the public protector's medical condition. Any person, any neutral person who sees that will see as the crassest display of a lack of ubuntu, empathy, humanness, and just being human. And again, if you use the test, the public protector cannot be expected to assume that a person who behaves like you did around that issue, even with those explanations you gave this morning, will treat her as a human being alone. Forget about fairness and all those things, just to be treated as a person. I have no doubt that if anybody that you respect or you care for was being impeached and they said they were sick, you would accept it. It's only because it's according to your previous statements, that was being done by this incompetent advocate, Mkoban. And really, I think anyone, even the most rampant racist Mkoban hater, would understand that she cannot be expected to assume the bona fides and the impartiality of someone who behaved the way you did on the 13th of September, 2022. And what is worse, which is at B11, Chairperson, is that members of this committee were pleading with you. Honorable Mautwe, Honorable Olomisa, Honorable Zungula said, please let's adjourn, Chairperson, so that we can have a consultation with the committee and deal with this matter of the medical information and the unavailability of the lawyers. And you refused flatly. Unlike when the evidence leaders wanted to shield Mr. Ndo from his alleged sexual escapades. And, you know, in fact, instead what you did was to cut out Honorable Mautwe and mute me for simply saying the things that I was saying in the calmest possible manner, to say, please listen to me, don't shout at me, and I want to assert the rights of the client. And I was muted. In fact, the muting was just, as I say, don't know about me, I'm fine, I can take care of myself. But the muting was just laughable in the sense that I had already muted myself at that point. But again, it's not the muting per se, it's just the type of conduct. And your dictatorial tendencies in refusing to have a meeting when the members were asking for it were, in our respectful view, a clear signs of bias, of a disqualifying kind, and impropriety, and a display of, as I said, undue patriarchal tendencies, which have no place in a fair process like this, particularly demanding to know what illness the public protector was suffering from. You know, none of us here, with our whatever positions were given, should play God or the super guardian of the, you know, the little girl who is playing sick type of thing. It's just nauseating to even go into the implications of what happened here last week here. None of us are the fathers of the public protector or the school principal or whatever, who must demand more than what we're entitled to. And for that, Chairperson, you are not fit to fill the position for which requires impartiality and ethical conduct. Remember that you are representing an organ of state, which is the Speaker of Parliament. and organs of state in terms of Section 195 of the Constitution are duty bound to act not just fairly, but also impartially and ethically. And there was nothing unethical about questioning somebody's illness in the face of objective evidence from medical experts, if you didn't want to take it from me, at least. Then I've already dealt with the last ground, which is B12, Chair, which is that the rationalizations which you have made in the public domain about your conduct and in this morning also are just aggravation, if anything else, because not only did you, as I say, the facts were put in a particular, with a particular spin, which is not what would be what would come out if we were to watch the actual footage of what happened, but based on the noise. Yeah, I mean, this morning, that's what you say. You're saying things like, well, when we asked for the postponement, no papers had yet been filed by the respondents. So what? I mean, what has that got to do with anything? If I tell you that at that time when we were speaking, actually the respondents' papers were supposed to be in at 10, which is why I really didn't even want to be where I was. And now there were even 2 respondents. In fact, there were 3. A third one threatening in the face of the acting public protector. So you know, but the point is, why do I have to go into those minutiae to you know, my word when I say that we're stretched and we're in the middle of an application should be taken at its word, unless if I've done before, if I've misled you before or said things that were not true, which I have not. Yeah, I've dealt with the issue of the personal information, and so the point, and you went into television shows, as is your right to do, but you then misrepresented the facts there, and even went as far as to say that for what happened there, I should be referred to the Legal Practice Council, which quite frankly, I don't mind. But it just, I'm raising it only to show your bias, in the sense that you already, not only did you prejudge the public protector, but you prejudged me. But you can prejudge me as much as you want. I don't, as I said, it's got nothing to do with me. But you cannot prejudge the public protector. I will deal with whatever you were trying to instigate in those TV shows when it comes from people whose job it is to deal with it, or anybody for that matter. I think by now you know my attitude to those things, but I don't want to make the thing about me. As I said, I'll look after myself. But as far as the public protector is concerned, she cannot be expected to accept that you are not a person who was really trying to bully. Insofar as you were bullying me, it was on behalf, or rather vicariously, to bully her, because I'm here representing her. Yeah. Chair, those are the grounds. I've covered all the grounds, I think, that relate to the chair. I just want to emphasize something which I just put in my notes here about, which relates, forgive me, Chair, for going back to this, which relates to the issue of relevance and some of the prejudicial things that have happened to not only to us as a team as a result of your conduct. Well, maybe that's putting it too high. Partially as a result of the conduct that has that has been displayed here, not only by you. But I have to go back to this. I can tell you for free that one of the issues that have been suffered by my team, and again, I'm only raising this because we're not crybabies, but I'm only raising this as far as it affects the public protector, is that my team, since we started this process here until last week, forget about the fact that that's in breach of regulations. My team has not been paid at all by the Office of the Public Protector, not 1 cent since for work which goes back, some of it to March. But I just want to refer to the period between June and now, where we were busy with this work here. It's fine. We'll deal with it when the time comes and in a manner that might be befitting. But Chairperson, what has happened to them is as I say, either a display of their letterheads and other details, which have when eventually last week they were supposed to be paid for the historical work, then it was interrupted by the fraud that I explained earlier, which we link directly to the fact that their documents were displayed there. But what is worse is the kind of relating to the issue of relevance now, is the kind of information that gets bandied about and deliberately abused, which is intended only to hurt, as I say, not to assist the committee, but simply just to, it's just vindictiveness, basically. I'll give you an example. We were told here that a so-called 148 million had been spent over a period of 5 to 6 years. And I don't know what that was in aid of, but it certainly achieved the intended effect of portraying that money as having been spent recklessly, I suppose, by the public protector. Nobody puts this in perspective that actually what you're talking about is an average of 25, 26 million per annum, which for an office of, the police spend about 300 million or I don't know how many billion in legal fees, just because of the nature of their Home Affairs spends about hundreds or maybe 75 million or so, and so on. But it's not put in perspective, just one figure. In fact, that 148, probably most of the departments spend it in half a year, not even in 6 years. Fine, that's fine. It's fine. If you open us up to that kind of gratuitous insults. But where we draw the line is where lies are then peddled and misinformation, because we were told that of that money, 49 million had gone to Sianejo. Well, firstly, thanks to Honorable Heron, even if that was true, it wouldn't mean that that money had been paid to Sianejo, simply because they are there to pay other people. But it's also not true. The actual amount of money is not 49 million. It's something like 27, I think, or 29 million, of which only not even a third, about a third actually goes to Sianejo. The rest of the money is paid out as it should be to, I think, about 5 or 6 different advocates, depending on which matter was being handled. Yeah. Now, as I say, all this we could tolerate if it actually was meant to assist the committee. But it doesn't assist the committee at all, except to portray Mr. Sianejo or some of us, at least those who care, as you know, I don't know, avaricious lawyers who have, quote unquote, according to Mr. Mailam, benefited from that money. So, and that's the kind of thing that gets bandied about here, to the prejudice not of us, as you know. I hope I can believe that some of us really don't worry about this. The worry is the impact of all this to the public protector. That's the person that we have to worry about, because when you do that, when you squeeze her legal team and not pay them for months, when you portray them as thieves and all that, what you are really doing is to try to strip her of her legal representation, or to discredit her legal representative and her, you know. So it's not about us. It's about the prejudice to the public protector, which is undue, unwarranted, unfair, biased, and cruel. And maybe let me just say this. The reason the Constitutional Court said the public protector is entitled to legal representation is because she's, apart from anything else, she's a human being. She's a South African. And when you are having a process like this against the mightiest organization called the state and the National Assembly, and you know, the committee of political parties and so on, and you are a sole human being, you know, surely you must be entitled to assistance so that the scales, as far as possible, can be balanced. No, but what is required here is that the state must use all its might to bludgeon her to death, but she must not do anything. She must not be represented. She must not have 2 weeks to prepare witnesses. She must not raise objections. What must she do? Yeah, absolutely. She must not even get sick, for God's sake. But anyway, and we're supposed to come here and smile and say we're in the land of impartiality. No, we're not. Far from it. Then, Chair, if we can go to the issue of Mr. Mileham. I'll be quick. Mr. Mileham, again, the first ground is inherent bias based on his relationship with Ms. Mazon. I'll just read it out so to save time. We said it's common cause that, it's paragraph 72, Chairperson. It is common cause that Honorable Mileham is the lawfully married husband or spouse of the complainant, Honorable Mazoni. It is also undeniable that Honorable Mileham has consistently displayed a hostile and condescending attitude towards the legal representatives of the public protector, and therefore by extension the public protector. The issues have been previously raised with the chairperson, who failed to address them adequately. Then we raise the first ground, which is the inherent bias of Mr. Mileham. So it is legally and ethically untenable to allow a person who suffers from a conflict of interest of the kind, which affects Honorable Mileham, to sit in the purported impartial determination of the guilt or innocence of the public protector or any other person in her current position. Now, Chair, again, this is trite. Let's go back to the issue of reasonable apprehension, Chair, that I raised. Again, Honorable Mileham might be the fairest and most balanced person in the world. It doesn't matter. The point is that should the public protector be reasonably expected to subject herself to the impartial and unbiased participation of Mr. Mileham in this process, when she knows that he is the husband of the complainant. Now that's got people can be husbands or wives of anybody that they choose. But the point is that you cannot expect that a person who's placed in that position. There are many cases, my learned friends will know them, court cases where people are disqualified. And I think I've made this example before. If I'm sitting as the CEO of Danel or whatever, and I'm sitting there adjudicating a tender or procurement opportunity, and one of the people who's tendering is my wife or husband, then surely it doesn't matter if I'm like, the saint of whatever, but I cannot be expected to put a neutral mind to bear in that situation. Or worse still, if there's another person who's a competitor, they cannot expect me to sit there. It's very simple, Chair. And we accept that it might have been done inadvertently. We know we're not now. We know that Honorable Mailam is an MP in his own right, and I'm sure whoever appointed him to the committee probably didn't think of this point that we're raising. We will prepare to accept that. But that cannot absolve him of the duty, now that it has been raised, to recuse himself. Nor can it absolve him from the duty to have raised it with you, Chairperson, at least. I don't know, maybe he did. But if he did, then you should have raised it with us. So I'm assuming that he did not raise it with you, because you would have given us an opportunity to either say it's fine or it's not fine. So I can safely assume he didn't raise it with you. And that's already a breach of the rules of impartiality and recusal, because he should have disclosed it, and he should have, he can't just sit here, and keep quiet about it, even before it's raised. And then when it's raised, he can't insist on sitting here. And neither should the DA, actually, if but I don't think they are that way inclined. But nobody in their right mind can blame the public protector for insisting that this should not happen. The second one, Chairperson, if you can put up RA6. Because this, what I've said there, then shows a predetermined outcome on the part of Mr. Milham, at least. Because remember, the interest of a complainant is only one. It is a finding of guilt. And so that's the outcome with which he's associated. So it's a predetermined outcome, just like your predetermined outcome when you proclaimed the public protector to be incompetent. Now, in line with this, this is what Mr. Milham does. And, the devil, Bofu, is supposed to enjoy all this, as I say, and play dead even when you are being provoked like this, which is never going to happen. Well, it happened in this case, unfortunately, because I respect this process, contrary to whatever anyone has to say. This is what I was subjected to, Chairperson, a few weeks ago. And I did not respond because I thought it would really demean this process. Honorable Milham puts up these tweets about me. Go to the previous one. The one that talks about predetermined outcome. Yeah, that was the first one tweet. Yeah. He says, I haven't made up my mind on Advocate Mkhwebane's fitness to hold office yet. If you believe that, you believe anything. But here's the important part. He says, yeah, Advocate Mpofu is rude, disrespectful, and unwilling to accept the rules of parliament. I don't know which rules. I will continue to stand up for the rights of witnesses and our right as MPs to ask whatever we like. Okay, move on. And then somebody must have responded to explain the rules of fairness. This is in the Code of Law, he says, right? The rules for cross-examination are court rules, not parliamentary rules. Okay. The less I say about that, the better. There's a big difference. I don't know what it is about the rules of cross-examination. So the rules of parliament apply to everyone equally, including Advocate Mpofu. If you breach those rules, expect to be disrupted. In other words, I must expect to be disrupted. Carry on. When he is dignified, this is me now, competent and respectful. So in other words, he's calling me undignified, incompetent, and disrespectful. He will be treated as such. Many others are every single day. Sadly, the advocate fails badly in this regard. Again, I mean, to be judged by someone like Mr. Malham is something that I, quite frankly, don't worry much about. But it's the implication that it has on the process. Yeah. I've been judged and tortured by people like him before, and then he then responds again.
Chairperson.
Okay, let me switch off chat.
Just a pause at in both days. You did not raise your hand, Honorable Myla.
I apologize, Chair. I'll raise my hand right now. Sorry, I don't know how to do a point of order. Okay. Sorry. Can I go ahead, Chair?
What is the point of order on?
Chairperson, he says he's been tortured by people like me. Chairperson, I'd ask that be withdrawn. It's unparliamentary behavior and it's unparliamentary language. I certainly have never tortured anyone in my life, and I take the gravest exception to Mr. Mpofu making statements like that.
Okay, thank you, Honorable Mylam. You certainly have not been tortured by Honorable Mylam, Advocate Mpofu.
I have. The chair. Okay, let me put it.
I would want you to
yes,
so that we are able to, listen to your presentation, to refrain from that.
Yes, no, thank you, Chair. Let me just explain, and then you can make a ruling. Maybe I can withdraw the remark that I've been tortured by people like Malham, Mr. Malham. I've been tortured by him, Mr. Kevin Malham. No, I'm telling you, I've been, when I say tortured, I mean,
let's do it step by step.
Yeah, let's do it step by step.
You've just withdrawn that.
Yes, I've withdrawn the earlier remark.
Yes.
I'm making a new remark now, which says I have been tortured by Mr. Kevin Malham. Torture doesn't just include the physical torture that I suffered in the hands of the apartheid regime, if that's what he thinks I'm referring to. That I've been tortured about as well. But here, I've been tortured by Mr. Kevin Malham by insulting me. He has tortured me emotionally by saying that I'm undignified, incompetent, and whatever he has said there. So he has tortured me. He can't define my torture.
Okay, that's fine.
Okay,
thank you, Advocate Mpofu.
All right, thank you. But let's move on, Chair.
Now, before you move on, so I want you to step back, Honorable Mylan, because firstly, you would have withdrawn the first reference, but is now making a statement about how he feels in the hearings in relation to your interactions with him. I don't want you to respond to that. Now let's proceed.
Thank you, Chair. So the point is that, you know, when the public protector is subjected to this kind of patent and obvious bias, and as I say, and when her representatives are subjected to that, particularly in the public domain, Chairperson, I'm quite sure you'll forgive me. I've called you biased and everything, but I'm quite sure that even you will not approve of a member of the committee behaving in that fashion and in social media. I mean, if I was so minded, I would have addressed Honorable Mylam on Twitter which I'm very capable of doing. But I decided not to do it because it's just really the lowest form of or the highest form of provocation, which I was not going to fall into, and that is why I'm raising it here, Chair, instead of raising it in that space. Because as a professional, I have a duty. I had a duty to await the correct opportunity for me to deal with the torture that I'm subjected to by Honorable Mileham. And that torture is directed at the public protector again, as I say. And that's what's most important.
Yeah. Just a pause there.
Yes, Chair.
Because I want to indicate to you where we are and the need for it to wrap up. I would have handed over to you at 17 minutes past 10, and you made your remarks about 5 minutes, and 22 minutes past 10, you indicated to me that's when I must start counting your 2 hours, which I gladly did. And I'm actually counting from 10:30. Not
So
even
we're
20.
now at 2 hours.
So now we are now at full 2 hours that
Yes.
I would have agreed with you that we're giving you.
Thank you,
So
Chair.
I'd want you to wrap up.
Yes, I will, Chair, but don't you see, I told you I'll remind you of the time.
Already given, as I indicated. in
All
the
right.
minutes.
Okay, Chair, then I'll try and wrap up. I'm almost there, Chair. Please bear with me. Right. So anyway, we've dealt with that. We've dealt with what I call the inherent bias of Honorable Mileham, which is just there. It's an objective fact. And the second one is the one represented by his gratuitous and unsolicited Twitter attacks on the representatives of the public protector. And I've said, Chair, that there are what we'll call aggravating factors there. Those factors affect other members of the DA, but so I'm not raising them against them as such, except to raise them as to show the aggravation in the case of Honorable Mileham, because we have to take him from whence he comes. And I've said that firstly, his conduct has led us to raise the issue that in any event, he's a member of the DA, and the DA leader, Mr. John Steenhuisen, stated on national television on the 9th of June 2022 that he and other members of the DA were, quote, popping champagne at the news of the unlawful, biased, improper, and malafide suspension of the public protector by President Ramaphosa on that date. And then so that's the first thing. So popping champagne at such illegality should itself be a disqualifying factor. And we say more recently, the DA has committed gross misconduct. And again, Chair, everything I've said against you, but I expect you to censor this kind of behavior very seriously. The DA went on last week to attach statements in this committee to their court papers, which were totally irrelevant. The court matter was about whether the public protector should, in the meantime, assuming that there are confirmation proceedings in the Constitutional Court, be at work or not. And I'm not exaggerating, the DA attached in their papers there, but 400 pages of the statements of Ms. Mokhaladi, statement of Mutsisi, Thejane, and including annexures, 400, 500 pages. On the day of before the hearing, they apologized because we pointed out, what is this now? What is the Section 194 statements got to do with this? Firstly, it was disingenuous and again, trying to create sensationalism. Because if, as we pointed out in court, if indeed they wanted, let's assume it was relevant, they wanted to bring the information from this committee, then what you do is you then bring the statement of Ms. Mukhaladi, for example, and bring the record of her cross-examination. You can't just bring the statement and wish away whatever has happened. So that was the first problem with it. And so the apology in that regard is not accepted, at least insofar as it was directed to us. The court, I'm sure, will accept it. Yeah. Secondly, Chair, that is a matter that might go up to appeal stages. So it means every time it goes there, there must be this 400, 500 pages, which are just a waste of everybody's time. So that's what they did. We know why they did it. It was to put those statements with all the negativity, the irrelevant statements, which we have said, and this is another reason why accepting irrelevancies can be harmful. But what takes the cake, Chairperson, and here we place this on your door, and again, unless if you can explain it, maybe this is where there's a cross-pollination between your recusal and the recusal of Mr. Mailham. The Democratic Alliance in those papers included the witness list of the public protector in the court papers. So it's now out there. It was actually written upon by newspaper articles. Now the problem with that, Chairperson, is twofold. One is that witness list, we only gave it to you. The witness lists have been exchanged here on the common understanding that those witness lists are not going to be publicized. When we received the witness list of the evidence leaders in June, they specifically and correctly and understandably said, do not share this witness list, because in there are names of people, some respected, some rightly so, some not rightly so, who appear, whose names appear on that list, that, for example, the evidence leaders have not called. So if we wanted to be sensationalist, we would have published the list and say, oh, look, so-and-so is on the list, look, so-and-so is on the list. But that would be disrespecting those people and disrespecting this process and disrespecting the evidence leaders who gave us the document in confidence. So when we gave you our witness list, the only thing we expected was to be treated in the same way, that it would be handled with the same discretion by all concerned. And Chair, by saying that, I don't mean that you should have hidden it. I'm sure you probably have an obligation to share it with the other members. I don't know. But whatever that obligation is, surely cannot extend in those people broadcasting a witness list, because it affects witnesses. As I said again, you can take it from the evidence leaders. Witnesses are people that you have to beg, because there's no other reason. They're doing you a favor. Yeah. So some of our witnesses are already saying, well, if our names are being bandied about before you even consult with us, we're not interested in assisting you. So the complaint comes at that level, that it affects the public protector's ability to defend herself in this process. And it's done gratuitously, hatefully, spitefully, maliciously, to achieve no purpose other than sensationalism. So that's the context in which Mr. Mailham's recusal is being sought. And for what it's worth, Chairperson, I am imploring you that before recusing yourself or asking whoever is going to take over from you, that that conduct, the Twitter conduct, and the inclusion, the biased inclusion of statements in the court papers, and the inclusion of the witness list should be taken up with at least the DA and or any other person here who might be inclined to do such a despicable thing. Okay, now, Chair, I know I'm now at your mercy, but allow me to then deal with the last section, which is quite important. And that is, I promise you, maybe I'll just read it out to make it easy as well. It's the last 2 to 3 pages. I'll just read it out, Chair. I think it's easier if I do that. We say in this section, we briefly outline some selected and well-established principles, which are, I'm reading from paragraph 82, which are applicable to recusal applications and on which reliance will be placed to support the recusal application or applications in this and any other appropriate forum. 83, we say bias can be classified into actual bias, I've already dealt with that, or a reasonable apprehension of bias on the part of the affected party, in this case, the public protector. Although it sometimes happens that actual bias is proved, majority of cases involve a reasonable